Hello, everyone, and welcome to Uncivil Law. And for today's case, we have a decision regarding the Second Amendment from every Second Amendment fan's favorite court, the Court of Appeals for the Ninth Circuit. This is United States of America versus Tamarind Edward Bomtess. In this case, the Court of Appeals for the Ninth Circuit says that carrying a concealed firearm is inherently suspicious of illegal activity. And the police, if they think you're carrying a illegal firearm, can stop you merely for carrying the concealed firearm because, carrying a concealed firearm is inherently illegal, don't you know? So the Ninth Circuit Court of Appeals thinks that carrying concealed, it means that there's reasonable suspicion that you're committing a crime. So that should make everyone super, super happy. But the details get far more interesting than that. Let's get started with this. On April the 18th, 2018, Ton and Barreto were patrolling Vallejo in a black police SUV. Barreto drove while Ton sat in the front passenger seat. At around 3:51 p.m., the detectives observed a group of 4 young African-American men. So we've got police here. With 4 young African-American men. So what is going to win in Ninth Circuit land? What's going to win in Ninth Circuit land? That's a good question. We could do one of two things. We can say, oh, this is racial profiling, and racial profiling is bad. Or we can say guns were bad. So what is going to win out? Our commitment to getting rid of racial profiling in police, or our commitment to stop all the guns? What's going to win between these two competing priorities? Who can say? Let's read more. As the detectives drove past the group, Barreto noticed that one of the men, Quentin Mills, appeared to be carrying a concealed handgun in the pouch pocket of his sweatshirt. Okay, so this SUV is driving down the street. I don't know what street this is in wherever they are, but let's assume they're traveling somewhere between like 20 and 30 miles an hour, since it's probably pretty reasonable. So they're traveling 20 to 30 miles an hour down this street, and this detective thinks he can spot a concealed handgun in the pouch pocket of a sweatshirt while they're on the move. Okay, Barreto made a U-turn so the officers could get a closer look. At this point, the men were walking eastbound on the south side of the street, and the officers were driving 5 to 7 miles per hour westbound, so they've slowed way down. But they're on the other side of the street now. Detective Barreto slowed the vehicle further as they approached the group. From the passenger street, Detective Ton could very clearly see the 4 men on the sidewalk, the opposite sidewalk, mind you, who were not very far away on the opposite side of the street. Okay, Ton observed that Bomtess, the guy who's suing here, was walking in front of Miles, who also had obvious indicators of having a firearm. They can tell, man. They have X-ray vision. According to Ton, based on his training and experience as a police officer, and ding, 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 we've said the magic words, both Bomtess and Mills had bulges in parts of their body that were consistent with carrying firearms in public. Outstanding. After the SUV passed by the group, the detectives turned around and pulled up behind the 4 men, exited the vehicle, and ordered the group to stop and sit on the curb. All 4 of them complied. Miles had his hands in his front pocket, where Detective Barreto suspected he was concealing a firearm. Barreto unholstered his service pistol, held it by his side, and told Miles to remove his hands from his pocket. Barreto then ordered Miles to keep his hands up, reached into Miles' sweatshirt pocket, and removed a Glock 19 handgun with a live round in the chamber. That's the mid-size Glock with a mid-ear chamber. And then he also had a 22-round magazine, which is not typical. The detectives then handcuffed and searched Bomtess, uncovering a loaded .40 caliber Glock 22 concealed in his shoulder holster on the left-hand side of his body. The handgun serial number had been drilled off, which, super illegal, rendering it unreadable. When the officers ran Bomtess's information, they discovered he was a felon in possession and had an outstanding warrant, also super illegal. So yeah, it's not going super well for Bomtess here. In May of 2018, a grand jury returned an indictment charging him with 1 count of being a convicted felon. Man, this guy's getting off easy, man. He didn't get the felony counts for the possession of the gun with the destroyed serial numbers. He's getting off light. The district court denied the motion to suppress, finding that reasonable suspicion justified the stop. So we had reasonable suspicion, Terry. The court determined the stop began when detectives exited the SUV and ordered the group to sit down on the curb, which is perfectly reasonable. That's the point where they were being detained, right? So that is a stop. That is the point where they were being detained. Sure. The court then concluded the detectives had an objectively reasonable, articulable suspicion at the stop's inception based on a visible bulge above Bomtess's waist. So based on this bulge, they had an objectively reasonable suspicion of a crime in progress. Okay. What would that be? Under Terry versus Ohio, an officer may, consistent with the Fourth Amendment, conduct a brief investigatory stop when an officer has a reasonable, articulable suspicion the crime is afoot. We know this standard very well. We covered it with some length and some distress in Kansas v. Glover. Anyone remember Kansas v. Glover? I remember Kansas v. Glover. I remember it super, super well. Yeah, we know about the reasonable, articulable suspicion and what it really means in the real world. Good times. Okay, Second Amendment fans. I know you were waiting. I know you were waiting for the part that was really going to irritate you. You know, you were waiting for it. And if you weren't already there, Second Amendment fans, this is the part that's really going to irritate you. The court is about to tell you that carrying concealed is inherently illegal. This is great. Let's read all this magic words. This will make everyone super happy in Second Amendment land. Okay. In California, evidence a person is concealing a firearm provides an adequate basis to suspect illegal activity and thus grounds to initiate a Terry stop. I would like to take note that the great state of California does issue concealed carry permits. Depends where you are, because my understanding in California, and someone will correct me if I'm wrong, but I believe I'm correct, is that they're issued on a county level. And some counties are pretty generous in granting them, and some counties, the exact opposite of those things. So some counties will grant them pretty easily. The more conservative counties and the more liberal ones, not so much, and you'd be lucky to ever get one. So they do issue concealed carry permits. But apparently, despite the fact that they do issue concealed carry permits, and they do exist, carrying a concealed weapon is enough basis to suspect illegal activity. Okay, how's that work? We have held that where our state law makes it generally unlawful to carry a concealed firearm without a permit, a tip a person is carrying a concealed firearm raises reasonable suspicion of potential criminal activity under Terry. This is so even if the tip does not state the person is carrying a firearm illegally or is about to commit a crime. So merely carrying it is enough. Under California law, which Bomb Temps does not challenge here, it is generally illegal to carry a concealed firearm in public. In Foster, this is even greater language. In Foster, we held that, quote, given the insignificant number of concealed carry permits issued in California, a reasonable officer could conclude there's a high probability a person identified in a 911 call as carrying a concealed firearm is violating gun laws. The very fact that we don't issue very many of them means that everyone is presumptively breaking the law. Outstanding. We conclude the officer in Foster was therefore reasonable, and so we'll do this Terry stop too. No problem. Under our case law, the reasonable suspicion analysis is different in a jurisdiction that has different rules for carrying concealed weapons. So this is super fun. So there are different rules in different states and different things in jurisdictions. You know, I have seen this case, or like, not this case literally, but this essential question, this core question. I've seen this core question come up quite a lot. I think I saw it come up in Pennsylvania once. I saw it come up in West Virginia once. I'm pretty sure I saw it come up in Florida once. Every case I've ever seen says, like, because we issue these things, you can't presume that merely carrying concealed is illegal. You need more. That's the case law we've seen, but not in California because it's so infrequent it doesn't count. So every court I've ever seen said, because these are legal, you can't presume it's illegal. But Ninth Circuit has no problem going the other way with California. Okay, so under our case law, the reasonable suspicion analysis is different in a jurisdiction that has different rules for carrying concealed. Holding that a tip that an individual had a gun in Washington State, which apparently issues these things on a very free basis compared to California, that Washington State does not support reasonable suspicion because carrying a firearm is presumptively lawful in Washington. Nice. But Bomb Temps was carrying a concealed, not to mention loaded, how would you know that from the observation though, weapon in California, and this conduct is presumptively a crime in the great state of the California Republic. That is not the end of this matter, however, because there's still a question of whether the officers had a reasonable suspicion he was carrying a firearm. So we've moved from carrying a firearm is bad to did the officers have a reasonable suspicion he was carrying a firearm? This part gets really fun too, guys. Fun in a sad way. This gets really fun in the court trying to split this difference. How did they conclude he was concealing a firearm as opposed to something else? How did they reach that particular conclusion? Okay, let's figure out how they reached that conclusion. The district court said they did because based on Detective Todd's testimony that Bomb Temps had a very large and obvious bulge on his sweatshirt sweatshirt that likely indicated a concealed firearm. Our existing case law in this area supports the district court's decision below. That is because our prior cases have given significant weight to an officer's observations of a visible bulge in an individual's clothing that could indicate the presence of a weapon, or any number of other things, but definitely a weapon. Bontemps, attempting to inject some sanity into this, argues on appeal that the bulge alone is necessarily unreliable because a bulge could be anything. It could be a lot of things. He gives some examples: candy, a gift, or a prosthetic. Could be a lot of things. You don't know, right, what this bulge is. But Bontemps ultimately acknowledged in oral argument what is, of course, true. What is true? In some circumstances, a bulge could be an obvious indicator of concealed firearm. For example, a bulge underneath a tightly fitting shirt. Yeah, I suppose if the profile is really, really clear, then that's possible, but yeah, no. Precedent suggests and common sense confirms what we hold here. A bulge that appears to be a concealed firearm, so apparently a reasonable officer can tell the difference. A bulge that appears to be a concealed firearm can form the basis of a Terry stop in a jurisdiction like the great state of California, where carrying a concealed weapon is presumptively unlawful. Carrying weapons is bad. You can't do that here, even if you have a permit. We have previously held, as explained above, a reliable 911 tip that a person is carrying a concealed firearm raises reasonable suspicion of potential criminal activity. Since that is the case, a reasonable suspicion standard should likewise permit this result based on an officer's own observation, grounded in experience, that a person is potentially carrying a concealed weapon under his clothing due to the bulge a firearm creates. Even if a bulge indicating a concealed weapon can be sufficient to justify a Terry stop, which apparently it can, there remains the issue as to whether these officers had reasonable suspicion to base it based on this particular bulge. So could they determine this particular bulge was a firearm? So here we return to the thrust of the argument, which is that the bulge could indicate many things, and the officers could be using bulges as a pretext for making unjustified stops. So this is where the Ninth Circuit is truly forced to face this demon. They're truly forced to face the demon. Maybe the officer is doing it as a pure pretext. He says he sees a bulge and he says he sees firearms. Maybe they're racially profiling because we're all black men. So this is the point in the opinion when the Ninth Circuit has to decide which way it wants to be woke. Does it want to be woke by saying, this does seem like a problem without something more, because officers could racially discriminate against black people, and that's really bad. And so we shouldn't allow these mere hunches. We should allow a little bit more, because racial profiling is such a scourge on us. Is that option one of how we want to be woke? Or do we want to be woke by saying, well, as long as the officer thinks that they can determine it, that's fine, because we think guns are bad, really, really bad, really, really bad. And so we don't really care as much about the profiling issue because guns are really bad, really bad, really bad. Which of these two options do you think they will pick? On this point, Bontemps argues the bulge in his sweatshirt, which was not suggestive of a firearm, which seems pretty unlikely because sweatshirts are pretty thick, right? It was in his pouch pocket. So it's one of those sweatshirts that has that you can put your hands in, in the middle of it. It has that pouch in the middle. And so he has a handgun there. And it's, sweatshirts are pretty thick. So, it wasn't a tight t-shirt. It's a sweatshirt. So yeah, how could you determine this bulge in this sweatshirt? In those cases, the court held the bulges in question did not create a reasonable suspicion to search for probable cause. Cases involving drug bulges, however, present somewhat different considerations than gun bulges under the fact of Terry. So if it were drugs, that would be, one thing, but these are guns. While guns are made of rigid materials such as metal or hard plastics and possess a relatively distinct shape, drugs or packages of drugs come in different shapes and sizes, some small, soft, and nondescript. The variety of drugs come in so many shapes and sizes, unlike those guns, yeah. While a drug bulge case involves some different considerations owing to the physical differences between the pocketed drugs and concealed guns, Bontemps' overall concern with indiscriminate stops based on bulges alone remains a valid one in the concealed firearm context, and it's a concern of which we're mindful. In this case, however, we conclude that district court's basis for finding reasonable suspicion was soundly supported in the record based on factual findings that were not clearly erroneous, and those facts taken together create reasonable suspicion of criminal activity. Detective Tan testified that he saw a very large and obvious bulge in his sweatshirt, the really thick sweatshirt, that appeared based on his training to be concealed. The gun was printing in this very thick sweatshirt pocket. This guy's powers of observation must be legendary. To reverse the district court's factual finding as clearly erroneous, we must determine the district court's factual findings were illogical implausible, or without support. Nothing in the district court's central factual finding was illogical or implausible. Okay? On the contrary, it enjoys ample support. From his vantage point, in a slow-moving SUV that decelerated further to get a good look, Ton could very clearly see Bontemps, who was not very far away, on the opposite side of a street in broad daylight. Bontemps was also carrying a gun in a shoulder holster, and thus on a part of his body where items would be less likely to be held. This is a nice little touch here. The dissent is thus incorrect in implying our holding allows any bulge of any kind to justify a Terry stop. That's not the right conclusion. No, it's not that any bulge of any kind. Our holding instead is that a bulge suggestive of a firearm can be sufficient to create a reasonable suspicion. And in their case, there was ample evidence from which to conclude the obvious bulge was likely a concealed firearm. Okay, so if you haven't spotted the problem already, which the dissent has spotted, I'm going to illustrate it for you further. The dissent says you're saying that any bulge of any size allows a stop. And the majority says that's not true. We're only saying a bulge that appears to the well-trained officer to be a firearm. Well, okay, so you're an officer. You're an officer in California, and you'd like to stop and frisk somebody for some reason. What now do you have to say that you observed based on your training and experience, even if it's not necessarily true? What do you have to say? What are the magic words you can say that would allow you to conduct this search? What would the magic words be? Let me see. It might be something like, based on my training and experience, I observed what appeared to be an outline of a gun that was bulging in his pocket. Now, the fact that that may or may not turn out to be true is completely irrelevant. But I had probable cause because I observed it based on my training experience. So all that has to happen, and I know this would never happen in California, so, shame on me for even suggesting it. But all that would have to happen is a cop would have to be willing to lie. For the foregoing reasons, which totally bear total analysis and don't have any problems, the judgment is affirmed. Thus, that brings us to the end of the case of United States of America versus Tamron Edward Bontemps. In this case, the Court of Appeals for the Ninth Circuit, which loves firearms very, very much, says that firearms in California are so rarely legally allowed to be carried that if you see one, you can assume it's illegal and stop and frisk them. And also, they don't actually really need to have a firearm on them to stop and frisk them, because all the officer has to say is that based on my training experience, I observed something that appeared to be the outline of a firearm, and then you can stop and frisk them. And whether or not that's true or not, you reasonably observed it in your training and experience. And this would never be abused in any way, because it's not like we have any concerns about police misconduct or overreach or abolish the police or anything like that. No. There's no chance the police will abuse this wonderful new authority in California. So, gun owners in California, move. And that brings us to the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.